let's go through the timeline. There's really sort of 5 instances of negligence or misconduct, one of which is clear criminal or gross negligence, in my opinion. And that is the last one. But let's just go through all of them. The first is you have a gun that reportedly misfired 2 or 3 times the Saturday before the shooting. That gun should have been removed from the set, period. It was not. That's negligence, civil negligence. Now you have staff members who are bringing live ammunition onto the set. Anywhere from 1, which killed Hutchins, to 500. We don't know what the mix was, but that's what Sheriff Mendoza told us today. There should never be live ammunition on a set. That's negligence. You have a situation where staff members are engaging in target practice during their break with live ammunition. That's negligent. You have Alec Baldwin himself pointing a weapon at a human being. Again, negligence. But all of this is simple negligence. This is where we get the gross negligence, the criminal negligence, Vinny. Sheriff Mendoza today told us that the armorer, Anna Gutierrez-Reed, and the assistant director, Dave Halls, they handled the weapon, they inspected the weapon. There was a live round in that weapon, in addition to other rounds. We don't know what those other rounds were, but those two, they were criminally negligent. They should be prosecuted for manslaughter because they played Russian roulette with someone else's life. And as a result, Helena Hutchins died, leaving behind her husband and 9-year-old son. Inspect the gun. The gun was not inspected. Hall's job was to inspect the gun.
And if it's
Again,
proven,
Mendoza said it was not inspected. They should be prosecuted. It's not a minor mistake. It's a fatality. This is how people die.
But if it's not inspected before that shot, or if it's not inspected that day at all, there are things that we need to discuss. Because if she inspected it in the morning and didn't inspect it right before the incident happened in that afternoon, that can be something that can be helpful to her defense.
Very strange what happened here. You've got a Lori Valadebel not competent to stand trial and getting some advice from the clinician to call an attorney, and that attorney has a conversation with her, and then attorney then says the nature, whatever was exchanged in the conversation, then gives it to the prosecutor. That doesn't sound right.
It's not right, but there's no Brady violation here. There's no constitutional violation. I love how defense attorneys like to go on the offense. But let's tell everyone what Brady is. Brady is a prosecutor's obligation to turn over exculpatory evidence to the defense. There's nothing here that's exculpatory. You have a criminal defendant who is unwell, incompetent temporarily to stand trial, who has a conversation with the clinician. The clinician shouldn't be giving legal advice. He or she's working for the state.
Isn't part of the problem here, though, Neama, that the clinician works for the Department of Health and Welfare? She is locked in there with, and this person is in charge of her and is treating her. It's not like she's voluntarily going to this person. To me, that's where this gets very problematic.
Well, no question. But when you're talking about the state of Idaho, the clinician may have done something improper, but that's so far removed from the prosecutor. The prosecutor shouldn't be communicating with a represented party. That's the ethical issue here. And even if you're communicating through an LDS attorney or through some other means, what you got to do is when you get that phone call and say, no, this is someone who's represented. I shouldn't be talking to her. That's your obligation as any attorney, but especially a prosecutor. So you say, listen, I can't talk to you without your attorney present. And it's just that simple. There's nothing exculpatory here. There's no reason that this hearing should go forward. Ultimately, Means is just upset because he has a client who is clearly unwell and has all sorts of issues, and she wants a new attorney. And she has a right to hire a new attorney.
Beforehand. You know what's interesting here, Neama, is that the person who actually squeezed the trigger is the one many see as being the least culpable.
Well, he's going to be civilly responsible because he's also the executive producer. But, I agree with Eklund and Kirk. I don't see criminal responsibility for Baldwin yet. I know, believe it or not. But I do see it for Hannah Gutierrez-Reed and Dave Halls. I mean, again, they told law enforcement, they told Mendoza that they inspected the gun. The gun had a live round. Baldwin reasonably relied on that representation. Again, that's negligent. I just don't think it's grossly negligent and grounds for manslaughter.